All right. Do you just want to do all the introductions and hello, Lou, and I'll
Yeah,
I'll
we'll
just
just,
be responsible for pressing stop when you're done.
that seems reasonable.
All right.
So, well, it's nice to meet you two. And Kyle, how are you?
All right.
Great. Where are you coming in from, Kyle?
Topeka.
Topeka. Okay, great. Well, so this is definitely a different sort of experience than we would normally have, but that's okay. We'll have a little bit of fun. I think a smaller group will give us an opportunity to actually have a little dialogue with each other as we go through this. So I starting on with no assumptions. So I assume with this crowd, you all have used Zoom before, but if you don't know how to raise your hand to ask a question, this is how you do it. But everyone knows how to do that. That's a skill you all have to use the raise your hand function if you want to stop or something like that. I assume that with this group, that's not a problem. Okay. Well, our plan today is to do a little bit of a mock class. Since it's just the three of us, I will go ahead and call on some folks and ask you some questions along the way and get a little flavor of that. But before we start with that, I want to lay out what it is that we're trying to do in a law class. So when you're in law school, the overwhelming majority of your classes, especially in the first year, will proceed with the entire class without any examinations or tests, and then at the very end, one great big final, which covers the entire grade. That's sort of the way that's done. We do that as a means of mimicking the practice of law, which is a series of high-stakes one-off events. So you don't get to do 3 trials and take an average of the 3, right? You do 1 trial. So we're mimicking that same type of experience here. So then what is it that we're doing in each class period, which we're going to be after today? Well, we're going to be playing with the 3 basic building blocks that we use in legal analysis in our classes. So we'll be engaging with facts. So of course, a good lawyer knows his or her facts cold, and also knows when they want to create facts. And I don't mean create facts in a illicit way, but rather if you're structuring a transaction or you're anything else, I can create facts which are better because I understand what those facts mean and what the ramifications for those facts would be. So we'll deal with facts and we'll look at those and how if the facts were different, we might have had a different outcome. We'll also look at doctrine, which is nothing more than a 50-cent word for rule of law. And so we may use, this broader term doctrine to cover different types of rules. And at a basic level, we might think that there's at least 2 different types of rules. A rule like drive 75, whereas if I drive 76, I've broken it, right? A really sort of off and on rule. Or standards, which is the speed in Montana, which is drive reasonably given the conditions. And so we'll see that most rules of law actually sort of fall into one of those or the other, either some sort of very delimited rule or some sort of squishier standard. And the way the rule of law is constructed might impact how I operate or how I advise my client to operate. And then lastly, we'll deal with policy. So we have rules designed to achieve some particular policy, right? So hopefully we don't have rules just for the sake of having rules, but we would have rules for the sake of achieving some particular end. And so we'll call that policy. So when you're in your classes in law school, we'll be working at how do I understand facts to determine the relevant ones from the irrelevant ones, what are the details and minutiae that matters, and what's the minutiae that doesn't. What are the relevant doctrines which I'll interact with, and what are the policy goals that we're after here. And in all those instances, those become tools that I can use to make arguments. Okay, and as we're zooming into our particular case, just a little bit of vocabulary. So we're going to look at 3 different terms about this idea of title when we're trying to learn how to steal stuff legally. My daughters have a new dog, and she's going crazy at the second. So 3 different kinds of title. Good title, which just means actual ownership, really owning something. So I have a certificate of title that you might have from with your car. You don't need a certificate to actually own something, but that just is a placeholder for us. So what it means to have good title. Void titles, flipping all the way to the bottom, is a bit of an oxymoron, but it means I'm in possession of a good, but I don't actually own it, right? That's void title. So if you went out and put a gun to someone's head and you said, hey, give me your wallet, you'd be in possession of that wallet and you'd have void title. So you would actually not have, legal ownership of it, even though you were in possession of it. And then lastly, we have voidable title, and that's what we're going to talk about in our class today. This idea that maybe there's some sort of specially stolen goods that I can pass to someone else and transform that into good title. So good title, void title, and voidable title, right? Those are the three basic concepts we want to work with today. We're going to do that against the backdrop then of a case. Did you all have a chance to read this little case? Yeah? Okay. So I'm going to give it a try over Zoom of doing our Socratic dialogue with it. So Brittany, I'll call on you first then, if you can unmute yourself. And I'd like to start out with, what are the basic facts of this case? What's the story that happened in the world that gave rise to this lawsuit?
I assume I'm Brittany. It's Bridget.
Oh, Bridget, I'm sorry. Yeah.
I get Brittany all the time. It's
well,
fine.
the names go away, and I remembered it started with a B.
Yeah, I've gotten Brittany all the time. It's fine. So the basic case is that you have Archer Jewelers. I'm going to forget the other two people's names, but one person wrote them a bad check for $70,000 and then resold the 15-carat diamond to another party who wrote a good check for $40,000, but then they found out it was stolen, and so both the jeweler and the secondary buyer are trying to make the case that they should have it. Absolutely right.
So yeah, and we have Archer, right, who, as you said, passes the diamond. But it's also maybe important for us when we think about, he passed some certificate of ownership with it too, and that certificate of ownership follows it through the sale, and maybe that matters. We'll see. But he passes the diamond and the certificate of ownership to our hero Simmons, who writes a bad check for 70 large, back. So we have that. Then Simmons, of course, immediately, as you note, resells. But again, he passes the certificate to this third-party buyer. So again, that might matter to us when we're looking at that doctrine, exactly as you say. And he receives an actual check for $40,000 with real money, which I presume he converts into six-packs or gambling money or whatever it means. And so what is those are the background facts of our case, absolutely. And so what's our lawsuit about? Who's suing whom for what? I was going to point to you. Who's suing who for, can you go ahead?
Me?
Yeah.
As far as I didn't get to the full last page.
Okay.
But from what I saw, that I believe Verdult, I'm not sure if I'm pronouncing it right,
Sure,
is suing Archer that he should be the one in ownership.
Yeah. So we have this fight between the people at sort of the corners of my little triangle here on this suit to recover, right? So they want the diamond back, and it's Archer suing Verdult. And he goes, I want that diamond back. It's mine. I'm the actual owner, right? And that makes some sense. He feels that he was cheated out of the diamond. He didn't, right, really feel that he passed ownership to it, and he feels like he should get that back. As a background matter of property law, the general rule in property is that would be true. And so we'll look at our statute to help us out with this. So let's see, Kyle, do you recall what state this case took place in?
I actually haven't a clue. I didn't see that we were supposed to read this. That's my bad.
That's fine. And what about our other participant, who's I know is not Alice, but his name is evaporated on the thing.
Oh, are we talking about me?
Oh yeah.
Oh, did you ask what state this happened?
Yeah.
California?
Yeah.
I just scanned the first page.
Yeah. So it did take place. It did take place in California. Absolutely.
Oh, and just to chip in here, guys, the materials are available on the admitted students portal. So if you go to www.law.ku.edu/admitted, you can see the materials.
Thanks, Steve. So yeah, so this case took place in California, so it's going to be a particular California statute that would apply, and they have their California version of this thing called the Uniform Commercial Code, and in particular, it's Uniform Commercial Code 2403. It's an interesting statute, this thing, the Uniform Commercial Code, and that 49 of the 50 states have enacted this very same statute. So the law in Kansas on this particular point is the same as the law in California, which is the same as the law in Maine, and so forth. And so when we're thinking about Archer, and he says, hey, that should be my diamond, Archer is relying on the first sentence in this paragraph from the statute. And that first sentence is in essence saying, if you purchase something, you can only get so much ownership, so much title, as the seller has. And he's like, well, gee, Simmons had, illegally held it. And so what did he get to pass? Nothing, because he didn't have legal title to it. So what did he pass to Verdault? Nothing. That's his position. Looking to the first sentence of this statute. What we have then from Verdault, though, is that Verdault's taking a different approach. He's looking, well, okay, true, but there's a second sentence to this statute, right? And the second sentence says a person who has so-called voidable title has the power to transfer good title to someone who's a good faith purchaser for value. So what's going on here is a relatively typical legal problem. You have party one who's relying on one particular statutory phrase or body of case law or regulatory rule, and then party two that is relying upon a second one, right? And these two rules seem to be in tension. And they're arguing back and forth which one should apply. Well, the court is going to say, well, gee, we're going to look, if this secondary rule applies, that's the one we're going to apply. And let's see if we do have this thing voidable title. And so if we were to walk through the case a bit more in person, we would say, let's try to figure out whether this thing voidable title happens. And we would see that we get a voidable title in some really unusual situations. Those would be situations in which the original good, in this case the diamond, was transferred under a thing called a transaction of purchase, which means a voluntary transfer. And that voluntary transfer was coupled with one of these four different, what I call statutorily approved swindles, right? And in this particular case, a check that was later dishonored, right? So we have here this transaction of purchase, which is a voluntary transfer, right? Coupled with a swindle, in this case, bad check. That would be contrasted with things which are not transactions of purchase, such as gun to the head, give me your gun. That's not a transaction of purchase. That's not voluntary in any way. Whereas in our case, Archer actually gave up the diamond freely. He wasn't threatened. He was just conned, right? So here he was conned. And so if I am conned out of my goods, what does that produce? That means that the person, the conner, the bad guy, the thief, in our case, Simmons, gets this thing called voidable title, and we'll see what that means here in a second. I have just a really bad joke, so why would people pass, bad checks? It's easier than credit card fraud. The criminal penalties are less. So just a little, put that in your back pockets. Easier to pass bad checks than to do credit card fraud. So, if you've learned nothing else today, it's that. If we were to jump back to our case, then we would go back. I would ask you guys, hey, what type of title did Simmons take from Archer? And again, we have three different types. It can be good title, right? He's the actual owner. It could be void title, the type of thing that comes from an actual aggressive theft, right? Stealing it when you weren't seen, or someone under direct threat and taking it. Or it could be voidable title, and voidable title comes from only those types of transactions which we have a transaction of purchase, a voluntary giving up the good, coupled with a swindle. And here that's what we have, right? We have this transaction of purchase, voluntarily gave up the diamond, coupled with this statutorily approved swindle. And what does that give us? Voidable title. Okay, so we have voidable title. So the question would be, you know, are we absolutely sure that we have voidable title? And again, if we were in class, we would crank through this statutory phrase a bit much, figure out, hey, is this a transaction of purchase? And we would look at the definition. We find that, yes, any voluntary transaction is a transaction of purchase. And that gets us to that first half of the statutory definition. And then similarly, we would look at the second half. Hey, do we have the appropriate type of swindle here? And we do. So Simmons has voidable title. So what does that mean? So I'd like us to have a conversation. We've been looking at this. What does it mean? So our guy Simmons, the thief in this story, he has voidable title. So what? What does that mean? What does that empower him to do? Anybody have any thoughts on that? What results from him having voidable title as opposed to just void title? Richard, I'm tempted to pick on you again.
That's what happens when you know my name.
Yeah, I know.
I would say voidable title means he has more legitimacy of a claim than a void title, but he still doesn't really have a legitimate claim to the item at hand. I mean, and if he had not then tried to pass it on to the next person, the bank could have sued to get the diamond back in the same manner and reclaimed it.
Right. And so that's pretty close. So Simmons in and of himself has nothing. So he is still not the owner. And if that diamond was still in Simmons' possession, he would not be able to remain in possession versus Archer, right? He doesn't have really any ownership to it at all. He just has this thing called voidable title. What voidable title does, however, is it comes with one distinction. This is the one thing that makes voidable title different from just a regular theft. It means that Simmons has a power, a unique power, a power to transfer that otherwise stolen diamond to a good faith purchaser for value. And that good faith purchaser for value now is the actual owner. So only because we've moved that diamond through this guy Simmons, and when he transfers it to this other person, that person becomes the good faith, that person who is a good faith purchaser for value becomes the actual owner of the good. So what we want to do back looking to the facts of our case is figure out, well, gee, is Verdult then this person who's a good faith purchaser for value? Because if he is, he's the actual owner of the diamond and not the original owner. So we see that our statute, like before, implicates three statutory definitions. So it's a very lawyerly kind of thing. We're going to look at each prong in the statutory definition and not just sort of think about it normatively, but rather, what does each provision mean under the statute? And so we would go through and look. So the first thing is that we know it's good faith purchaser for value. So only lawyers would define good faith because we're bad people. So we would define, because we can't leave that up to people's just instinct. So we would define what good faith means, and we would see that our statute, the Uniform Commercial Code, actually defines it. And it means honesty in fact. And if you were a merchant, meaning a person of business, it might mean honesty in fact plus following objective commercial standards, right? So it would mean both things. So good faith has this definition, honesty in fact, if you are a merchant, a person of business, following reasonable commercial standards. Purchaser means someone who takes by purchase, meaning someone who voluntarily receives something on a transaction. And then for value has this technical definition, but it just means that you traded something back. It wasn't a gift, right? So a good faith purchaser for value. So here we want to know, hey, so was Verdult a good faith purchaser of value? So here, Kyle, I'd ask you to play along with us. Let's try to figure out whether Verdult was a good faith purchaser for value. You still with us?
Yes.
All right. So let's start with value. Did Verdult pass value for this diamond?
Yeah, he paid $40,000, though I would question whether that's a legitimate value of the diamond since the initial purchase was $70,000. I feel like that would be a standard in the good faith argument.
Yeah, but let's do it one piece at a time for sure. I think that you're right. But let's ask first, did he pay value? He did pay value. Now, because there was this discount, maybe that discount is enough for us to be concerned about good faith, but did he pay value? He certainly did, right? He certainly paid value. Is he a purchaser, Kyle?
I suppose in that he transferred value for the good as per 1/201/33.
Absolutely, and well done, right? Good, yeah, absolutely. Because he is engaged in this voluntary transaction, and that's the way the statute defines purchaser, he's definitely a purchaser. So we have a 3-step definition here. He's got 2 of the 3. We're almost there. But you spotted already, and we call this in the law issue spotting. Hey, good faith seems to be something I'm concerned about. And the question would be, did he act in good faith? So before we get there, remind me what the standard for good faith is. What is that standard?
They did so honestly.
So honesty in fact is the general standard. So that means the so-called pure heart and empty head defense, right? So if I only require honesty in fact, right, even though you go like, wow, really? You bought it at that kind of a discount? Jeez. But you go like, I didn't know. It seemed good to me. That might be enough. Is that honesty in fact standard the only standard that applies to Verdault in this case? And I'm recalling you didn't get a chance to read it. The case, in our case, Verdault is someone who runs a pawn shop. And so that makes him a person of business. So since he's a person of business, Kyle, what would be the additional standard that would apply to him?
I would expect some kind of certification of the legitimacy of ownership to transfer between the seller and the shop.
Perhaps, and that's a different, good job, and that's a slightly different answer than the speaking to the facts. And then the question I asked you was one about the doctrine, and which was, what's the standard? So as we mentioned, a standard for a commercial actor requires commercial reasonableness, right? So not only must he be honest in fact, but he has to behave commercially reasonably. So we would have to figure out 2 things. Was he honest in fact, and did he behave commercially reasonably here? So you mentioned that, and so I'd like to switch over to Alice. If we're trying to figure out whether Verdault acted in good faith, what are the facts from our fact pattern that you think help support the notion that Verdault acted in good faith?
I don't know this question.
Yeah, so let's think about it together. So we've talked about that Verdault purchased this diamond for $40,000. He runs a pawn shop, and he got the diamond itself plus the certificate of ownership with it, right? And so if you're looking at that, what would be the things that make you think, hey, he acted in good faith here? Alice, still going back to you. What about
that I paid $40,000 in actual value, like not in a bad check.
Right. Well, so sure that Verdault did that, right? So he paid that. I guess the question, when we're asking the question, did Verdault purchase in good faith? What is the question that we're trying to get at? Kyle, what is it when we're saying, hey, Verdault, you acted in good faith? What are we trying to suss out about him?
Whether or not he knew the item was somehow achieved or gained under less than savory circumstances.
For sure, right? So the question is, he's trying to figure out whether, whether he knew it was stolen, right? Hey, did you know you were buying stolen goods? So Alice suggests, the paying of good money for that supports that, and maybe it does. I would also suggest the fact that the diamond came with a certificate of ownership probably helps to support Verdault's claim that he's a good faith purchaser for value, right? Because this diamond was coupled with the appropriate documentation. Kyle, you seemed not in love with Verdault, and so what are the facts that you think suggest that he did not act in good faith?
The other thing that I would suggest is that the discrepancy between these two sale values is substantial, almost 50%. And that kind of suggests that the diamond may be not being transferred for proper value, which would lead me to believe that it was probably not the most directly obtained good.
Yeah, maybe so. Does Verdalt know the original purchase price when he
Probably
purchased it?
not.
And so does that change that fact for you?
Not necessarily, because I would expect a pawnbroker to be able to, in some way, shape, or form, slightly assess the valuation of the diamond that he's purchasing for a sale in the future.
And you think that range, he's outside of a reasonable range?
Potentially, yes.
Yeah, arguably so. Arguably so. On the flip side, has anyone here? We don't have to raise our own hands, but has anyone here ever sold something to a pawn shop? I'll raise my hand. I have. When you sell to a pawn shop, do you get full value for that item?
No.
No, you never do. Right? You're engaging what's called a spot market. So you sell at severe discount, but you get cash immediately. Right? And because the pawn shop broker is always going to resell to someone else. So the other argument would be, you could say, well, it came with a certificate of authenticity, and pawn shops always sell at discount. Plus, this is a weird heart-shaped diamond. It's hard to know precisely what the real value is. It's going to be more an art than a science, most likely. But in any event, the court has no problem finding that Verdalt is a good faith purchaser for value in this case. Right, and they say, well, it came with the documentation. It was, wasn't so low as for us to believe that it was clearly a fake transaction. And the court says Verdalt's a good faith purchaser for value. What remedy would this leave then for Archer, the original owner of the diamond? The only remedy that he has is a suit against Simmons, which, happy days. Simmons is a thief. He's already converted all that $40,000, of course, into, gambling winnings or Corvettes or whatever else that he does. That money's evaporated. So the person who left without anything is Simmons. Or, excuse me, is Archer. So we've engaged in a little bit of a discussion of a case. And then the next thing we would do, having understood that case a little bit in law school, we would go through some hypotheticals and maybe play with the facts of the case, changing the facts to see how the doctrine would respond with new facts. So let's go ahead and give that a try if we can. So we'll call this one Hypo 1. So the same facts as in the Simmons case, except that Simmons offers to sell the diamond for $5,000. Would Verdalt be a good faith purchaser for value in this case? So Kyle, what are your thoughts if we reduce that value down to $5,000?
At $5,000, I would assume that it's almost certainly stolen.
That's probably true, and especially against the backdrop of Verdalt as a pawn shop owner has not just that honesty in fact, but also reasonable commercial standards. So we would have to say, even if Verdalt is just a really stupid pawn shop owner, it would maybe getting to the point where it's being so low that just as a matter of objective reasonableness, that can't be a good faith offer. At least as an argument, right? And there's no yes or no button we can push. But I think you're right, and I would tend to agree with you on that. We can make it even a little bit easier. If the diamond was not accompanied with the documentation, would that get us to the point where we would think, gee, this person is, not selling me something that they actually own? And I think, most likely, yes, right? That would for sure get us to lack of good faith. Let's try a different one. What if Simons gave the diamond to his mom as a gift, right? Of course, mom believes that Simons is a great guy. So finally, he's appreciating me, and he's giving me this lovely gift. So Bridget, let's go back to you. Do you think that Archer could collect the diamond from mom if Simon's had given it to mom as a gift?
Yeah, they should be able to collect from mom because she's not a purchaser on any level. She didn't exchange anything for it. She didn't get a title. I mean, as far as she knows, she just has it.
So let's walk through it. And I think that Simon still is has voidable title, right? Because he took as a transaction of purchase and with the con of bad check, right? And so then with that transaction, that gift to mom, does mom take it in good faith?
It's a good question.
So
she sees it as an honest transaction. I mean,
and is mom, unlike our pawnbroker, is mom tied to a commercial reasonableness standard or just honesty in fact?
Just honesty in fact.
Right. So long as mom loves her son and believes that he would buy her a gift, that's enough. Yes.
Yeah.
So mom acted in good faith. And you think that mom's not a purchaser. And I would go back to our definition of purchaser. And this is just a little bit of lawyering. We can't really use our common sense understandings of things. Purchaser is actually defined as anyone who takes voluntarily, including gift. So under this statute, gifts are purchases.
Okay.
Which are weird. So she is good faith. She's a purchaser, but is she a purchaser for value?
No.
No.
They didn't exchange anything.
Absolutely. Okay, good. So it's the lack of value here that is the thing that's sinking this ship. So again, as lawyers, just saying, well, it doesn't work isn't enough. We have to say particularly why. And so lastly, then, when we were in class, we would want to know, well, why would we do this? So we've looked at the doctrine here. We've tried to understand some facts, and we've changed facts to see how the doctrine would operate against different facts, and noted that there would be different outcomes. And the question would be, well, gee, what's the policy that we're after here, right? What are we trying to do? And normally I would have us sort of discuss with ourselves, how this would go, but let's just start with some ideas. Kyle, you're on the top of my queue, so I'll start with you. What policy goal might we be after with ensuring that the person at the bottom end of this chain of weird transactions gets to keep the good as opposed to the person at the top end? What thoughts do you have for that?
So that the person in the middleman action isn't swindling both sides out of their goods and money.
Okay, so to try to keep that guy from having a double con might be one policy goal we're after. Good. Alice, what do you think? What policy goals might we be after here?
I was thinking about the bad check. Like maybe that transaction could be reversed or
Okay.
Yeah.
Yeah, so to see which one could we fix easiest, perhaps. Good.
Mm-hmm.
And Bridget, what about you?
I wondered about when you get voidable titles from past things, but maybe you don't know that you got a voidable title.
What does that? So maybe you've received a voidable title in the past, you didn't even know it, and
Yeah.
what does that mean for you?
Yeah, so are you just out of luck, basically, to protect somewhat the purchaser?
So absolutely, those are three things we could think about, and I think that we're sort of orbiting the policy goals that the drafters of this were after. I think we would start with sort of a 50 cents economics word called the lowest cost risk avoider. And the idea of this concept of lowest cost risk avoider is this: if there are two people and one of them necessarily has to be injured, and that's really what we have here. We have both Archer and we have Verdal. We have two people who are otherwise innocents, that neither of them stole from the other. But somebody's going to be injured, right? Either I'm not going to have the diamond or I'm going to have spent $40,000 and got nothing. As between two people who are innocents, we should put the harm on the person who's the lowest cost risk avoider. And what that means is who could have protected themselves at the least amount of cost? Well, that is Archer. instead of just taking a personal check from someone for $70,000 and not waiting for it to clear, he could have waited a day. He could have demanded a cashier's check. He could have called the bank to make sure that check was going to clear, right? There's any number of steps he could have taken to protect himself, because which would be cheaper than the type of investigation of title that Verdalt would have had to have done. So Archer's the lowest cost risk avoider, therefore he should be injured. Secondly, a bit more utilitarian reasoning is that this particular rule encourages people to purchase. So in a different world, when it was Friday night and we were free to walk down to or drive over to Walmart to pick up a blender, for margarita night, right? And you go up to the cashier at Walmart, you don't ask, oh, before I purchase this blender, I would like to see the chain of title, please, going all the way back to the component parts in Vietnam. And I'd just like to make sure that each different assembler along the line actually paid full value for those parts. Because I don't want any of these people coming as against me and taking my blender away. I'll wait here while you get that done, right? We do that type of thing when we purchase real estate. And we actually have you investigate chain of title, and there's title insurance, and it takes a long time. But real estates, for many people, are once, 2, 3 time in a lifetime transactions, and they're high stake transactions, and we can bear that sort of cost. But for normal goods, if we actually made you trace title for every time someone purchased something, the economy would come grinding to a halt. No one would be able to purchase things. So we have this particular type of rule to protect the end user, saying, go ahead and purchase, and so long as you were a good faith purchaser for value, not to worry, no one's going to come and take your TV away or your computer away or your car away, right? You could have confidence that you're the owner. So we will allow an injustice to happen to someone like Archer to protect the broader system of the economy. And we see these types of things at law all the time. So the exclusionary rule, which is a rule from criminal law, criminal procedure to be a bit more exact, where you may have heard of, well, gee, the cops found the drugs on this guy, but because they did the wrong type of investigation, they let this guy walk. Whoa, what a travesty. It's the same type of reasoning here. We have a rule that says, hey, police, if you do the wrong type of investigation, these people are going to walk. You're the lowest cost risk avoider. Do the investigation the right way. And we will allow certain people to walk to protect all of us, because if we had no punishment for wrong investigations, what would happen? Well, the police would just act without warrant all the time. And they would just stop everybody and open up everyone's trunk and search everyone's house all the time, because there would be no punishment for them on the back end. So a similar type of utilitarian reasoning there. So that would be a discussion of policy, right? So we went through facts, doctrine, policy to try to understand what's going on in this area of law. And, again, we would have had more discussion in a live setting, but that gets us to the end of this little mock class. Here's my contact information. I'm happy to visit with folks. But if folks have questions now about law school class, anything, I'm happy to visit with you. Kyle.
This is actually not associated with the class, but with the topic at hand.
Sure.
So let's say I am harvesting some kind of mineral or something of that nature, mm-hmm. and I have a mine that runs under a different person's property. How does that work in terms of good title or voidable title?
That's a good question. So American law treats minerals and oil as part of real estate until such time as it's separated from the real estate. So the rule that we were dealing with in this case is a rule about goods, which are movable, tangible things like chairs and tables and diamond rings. And so the rule that you're asking about would be a rule about real estate. And that would just be a straight up theft case. Does that answer your question?
Yeah, that's fine.
So yeah, don't do that. Any other questions that folks might have? Questions for Dean Friedman?
Well, I just want to thank everyone for coming today, and thank Professor Mulligan, of course, for sharing that class. Of course, Professor Mulligan usually teaches this in front of 50 or 60 students, and he's very animated. He's not good at sitting in front of a camera still for 30 minutes. So thank you so much, Professor Mulligan, for doing that. Thanks to all of you folks and for everyone who watches this video. We really appreciate you spending some time with us.
I think we have one more question from.
Absolutely. Tyler,
there's a hand raised. I think that came back.
Yeah, so this kind of goes to the class question. Is it typical in your classes to make the presentation slides accessible after class, or is it typically just notes you take in class are the ones you bring with you?
For me, and my colleagues are going to differ. For me, I would always have my slides available after class. For me and an actually growing number of my colleagues, I think actually a majority now, I do not allow first-year students to use laptops or iPads or whatever in class. All the data suggests that you will perform worse on examinations if you are using a computer to take notes or that type of thing, than not. So I would ban that, then I'll give you the slides afterwards, so we would be able to have more conversation. And see, all of a sudden now that we have more folks on the call than were showing up for me before, but this is surely my user error. So if I didn't call on you, it's not because it's just that I didn't know that you were someone who was there. But that's normally how that would go, and most of my faculty colleagues then would go ahead and allow you to have that after the fact.
Thank you.
alrighty. If there's no more questions, again, I just want to thank everyone, and this will be available on the Admitted Students portal for watching. And there's a whole bunch of videos on there. Thanks for joining us. We look forward to seeing you in the fall.
Take care, everybody.